Hi, Nick Dogan, North State Law. We safeguard your professional license so you can get back to business. Today, we're going to talk about the process for dealing with an unlicensed general contracting complaint in North Carolina. So, previously talked about how to deal with a complaint if you're a licensed general contractor in North Carolina. This is going to be a wholly separate process. You got to look at it this way. If you're licensed in North Carolina, the General Contracting Board has authority over you, which is called, basically they have jurisdiction. They're going to be able to keep it within the purview of their system with their board. So they're going to be able to basically, quote unquote, prosecute you without having to go to actual real court. With the unlicensed stuff, they don't have authority. Well, they don't have jurisdiction over somebody that's not licensed under their board. So, for purposes of having somebody from the state make a decision regarding whether or not you actually did unlicensed work, they have to go into real court. So they have to file a complaint for an injunction in Superior Court. They're allowed to do it in Wake County, which is where they're based, and that's where they file it. So the first thing that somebody that is accused of doing unlicensed general contracting work in North Carolina will receive from the North Carolina Licensing Board for General Contractors is a notice that a complaint's been filed against them. They'll be given an opportunity to submit a statement and supporting documents showing that, hey, I didn't do any unlicensed work, or I did unlicensed work, but it wasn't $40,000 and above. If you do work and it's $20,000, labor and materials, you're fine. You do labor and material work, jobs completed, and it's $39,999.99. Guess what? It's not $40,000 and above. You're fine. But you have to be very, very careful. You could be doing a job that's $32,000. Somebody wants a couple things changed, or labor and or materials rise unexpectedly, and you end up $40,000 and above. That's going to be unlicensed general contracting. Then you're going to get that aforementioned notice that a complaint's been filed, and then the board is going to proceed on down that particular process. So before we get into the nuts and bolts of that, let's talk about the three types of people that file these complaints in the first place with the GC board. Those are typically going to be somebody from the planning/permitting department for whatever county or city that you're doing work in. You're also going to get a lot of complaints from the homeowner themselves or whoever's owning the property if it's a commercial property. And then you're sometimes going to get it from a competitor. I've seen that happen multiple times where a competitor sees somebody that's, in their opinion, doing unlicensed work. They'll file a complaint at the drop of a hat. So those are going to be the three main ones where you see your complaint filed from. So let's get back into the process. So, all right, you get the notice that a complaint's been filed. Let's say that you want to provide them with documentation and information showing that this project wasn't $40,000 and above. You can do that. Submit everything over to the board. Their review committee is going to review it. They're going to decide whether or not enough probable cause to exist to send this over to Superior Court. They could come back and go, you know what, you're right. Sorry about that. You're not going to get the apology, by the way. But they could say, all right, there wasn't enough here. We're going to dismiss it. Or, and most likely, they're going to say, all right, we're going to go to the next step. We believe that there's enough here to show a Superior Court judge that, yes, there was unlicensed general contracting work done that was $40,000 and above. So what they have to do is they have to file a complaint for an injunction and a summons with Superior Court. As I said, they do it in Wake County because that's where they're based. So they file it. We've got the fancy updated, sometimes working, sometimes mostly not working, online filing system. They file it there. And then after they get it filed, they have to send the defendant, which would be the alleged unlicensed GC person that was allegedly doing the $40,000 and above work. They've got to send that person a copy of the complaint and the summons, and they got to send it under what's called Rule 4. Typically, they'll do sheriff or certified mail. Sometimes they'll do both. Just make sure that they get service. They might have a sheriff coming by the office one day or at the house. They'll have a summons and complaint for you. They can leave it with somebody that's at least 21 years of age, of seemingly sound mind, that's a resident of the house. I'll tell you about 18 years old. So let's say they do all that, they get proper service on you. The next thing that's going to happen is that clock's going to start running. You got 30 days to file what's called a responsive pleading. Responsive pleading means you can file an answer saying, I admit that this happened, I deny that this happened, or you know what, I don't have enough information to determine whether or not this did happen. And you say, therefore, it is denied. So you could do that, file the answer, and then you go on to the next couple steps, or you can file what's called a motion to dismiss. That counts as a responsive pleading. The biggest thing, whichever route that you go and whatever responsive pleading that you file, that is going to need to be done within 30 days of when the summons and complaint was received. All right. There is one exception to that. You can do a motion to the court to get an additional 30 days. All right. So you can end up with 60 days. You do have to do something, and it is basically just filing a motion and filing a proposed order with the court, and then you can get your additional 30 days. So let's say you're served on August 1st. Your 30 days will be up at the end of the month, but you filed a particular motion that gets granted. Then you get another 30 days. So your answer is going to be done. Your responsive pleading is going to be needing to be filed by the end of September in that particular example. So, all right. So let's say you do your motion to dismiss or your answer. You get to the point where, all right, well, maybe I did do this. All right. What do you do at that point? Well, you can actually come to them and say, all right, sorry, made a mistake, and they can offer you a consent order. Consent order is basically saying, okay, this happened. It's going to have what are called findings of fact in it, conclusions of law, and then it's going to have kind of what I always call the decretal section, the order section. That's the meat and potatoes of it. That's what you have to do per the judge. Now, this is going to sound very silly, but with the consent order, it's an injunction saying that person that was doing unlicensed work 40,000 hours and above, you can't do unlicensed work 40,000 hours and above anymore. Well, per statute, you can't do work 40,000 hours and above. So why does it matter if this injunction is filed with the court? Great question. The reason being is the statute does allow for prosecution as a misdemeanor for doing unlicensed work 40,000 hours and above. Realistically speaking, though, law enforcement doesn't want to get involved in that because that's just a ton of work and you clog up the criminal court system. So instead of doing that, they clog up the civil court system. And it's a lot faster of a process, though, in the civil court system here, because if you get that injunction put in place, you can get it put in place pretty quickly, to be honest with you. It's just a matter of working out particulars of a consent order. If you do want to go that route, one of those is trying your best to avoid paying a lot of attorney's fees from the board. They're allowed to ask for attorney's fees. They always do. They have it in the complaint for injunction. And typically, judges will agree to allow them attorney's fees and costs as well. They're going to get costs for filing fee for Superior Court, paying the sheriff for the service fee, things like that. So one of the things that you can do if you do agree on a consent order is, hey, let's work on getting the attorney's fees knocked down. So that is something to do on that. At the end of the day, though, the effect of an injunction is basically it's a court order that says you can't do this, and that particular thing is something that you couldn't do anyways. But if you violate it after it's signed by a judge, then you're then subject to the contempt powers of court. Contempt powers being either criminal or civil contempt, both can wind you up in jail. And you can also end up with civil fines also. So with the injunction, you got to know, all right, I'm going to be very careful. I'm not going to do any work that's $40,000 and above. As soon as you sign that and a judge signs it, that goes into effect. If 3 days after judge signs it, you end up signing a contract with somebody to do a $50,000 remodel, you're in violation of that consent order injunction, and you're subject to the contempt powers of court, and they can throw you in jail at that point. That process takes a little while, but you can still end up there. So you got to be very careful, and you got to understand, all right, I know what I'm entering into. I know how to avoid that, and I am going to avoid doing any unlicensed work again. Or I could just get a license, at that point, go through the license process, which is something that we can help you with. I've done a video on that before, so check that out as well. I've also talked about consent orders in a number of other videos, so if you got any questions on that, just check those out. So that's pretty much the long and short of it. The only other thing that can be done, like let's go back and go back into our example of you file a motion to dismiss. You actually have proof that you didn't do anything wrong, or that the board is not have enough information in their complaint to show that you actually did something wrong. You can have a hearing. That would be a dismissal hearing. Let's say that you win that, it gets dismissed, you're good to go. Let's say you lose the dismissal hearing, then you got to turn around and file an answer, which is fine. And then you can turn around and have a hearing on the merits of their case, which is something that you could definitely do. You don't have to take a consent order. Consent is the first word in there. You don't have to consent to it, and you don't have to enter into it without your consent if you don't want to. So if you don't enter into consent order voluntarily, there is no order. All right, they got to get it the hard way, if they get it at all. So you can have a bit of a lengthier process as well if you don't want to enter into a consent order. You never know what will happen. It depends. Every particular case is different. So there might be something that the board made a mistake on, and hey, maybe they are not able to show that you did any work $40,000 and above. If you go that route and you're able to show that they didn't do it, then okay, yeah, you can get that dismissed. Most of the time, things do end up with an injunction being put in place. So if that ends up the route that ends up happening with your case, you just got to remember, can't do any work $40,000 and above unless you get your license. Okay. If you got any questions, check out videos on my YouTube channel. That's North State Law's YouTube channel. You can check out a lot of blogs on my website. That's northstatelawfirm.com. And if you still can't find what you're looking for in either one of those spots, then feel free to give my office a call or a text at 919-521-8810, and you get a free 15-minute discovery call with a member of my staff, and keep building North Carolina. Guys, have a great day. Bye-bye.